Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. For today's episode, episode 141, we're going to examine life insurance under Code Sections 2042 and 2035. What I've found is that a lot of people tend to confuse these code sections without really looking at the fact that both apply to life insurance with respect to a deceased insured and how you might analyze that for estate and gift tax purposes. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. Now, with life insurance, one of the big benefits is that typically, with some exceptions that we're going to look at, the death benefit is received free of income tax by the beneficiary. So we'll look at the transfer for value rule in a minute, which is not really the focus of today's discussion, but also kind of ties into it. Now, what a lot of people don't realize is that even though the death benefit is received free of income tax, there's still a potential estate tax problem. That estate tax treats life insurance differently, and there's many misconceptions around this treatment that we're going to walk through. Now, starting off, there's several code sections that list out the property that's included in the gross estate. Now, Code Section 2042 is one of those, and it specifically includes life insurance proceeds in the gross estate of the insured, not of the owner, but of the insured if any of the following occurs. 1, the estate is named as the beneficiary. Or 2, the estate is not the beneficiary, but the insured at the time of death holds any incident of ownership in the policy. So that doesn't have to be ownership on paper of the policy. It could be the holding of any of these rights, such as the power to take policy loans, the power to pledge the cash value of the policy, the power to surrender the cash value of the policy, the power to withdraw dividends, and maybe even the power to change the beneficiary. Now, that code section is easily avoided by divesting the insured of all incidents of ownership during life. So you can do that by transferring ownership of the policy or any of these retained incidents of ownership to either an individual who's not the insured or to an irrevocable life insurance trust, an ILIT, as we'll see in a bit. Now, when we get around to that transfer, there's 2 ways to do so for an existing policy. You can either gift the policy or sell the policy. But both outcomes, while they have their benefits respectively, also have their own issues respectively. Starting off, a gift of a policy, even a term policy, can create a taxable gift for gift tax purposes. Now, generally, your gift of a policy will include as its value, at the very least, the unused premium for the year. So, if you're paying the premium on an annual basis and you've prepaid it for the year, then the closer to the renewal date you can get, the lower the cost of the unused premium is going to be. So that can reduce your gift, but the wild card is what's known as the PS58 cost. That's another component of the value, and that's generally going to be your cash value plus any reserve for death benefit that's not reflected in the cash value. And it's important to note that with the PS58 cost, that applies to a term policy as well. There can still be a reserve reflected in the value of that policy, even if it's not accumulating cash value. And a lot of people are surprised to find that out, especially when it comes time to fund an ILIT with an existing policy. And from what I've seen in my own personal experience, the valuation of policies has become much more erratic and overstated in the last few years. So, in addition to the valuation issues, if you decide to gift the policy, there's a 3-year look back under Code Section 2035, which says that if you transfer the policy by gift and then die within the 3 years that follows that gift, then the IRS ignores the transfer and those death benefit proceeds are still included in your gross estate. So, you have to outlive the gift by at least 3 years in order to avoid this estate tax problem. And you also have to make sure that with respect to the transfer, there's no other retained ownership issues under any other code section that could somehow pull ownership of that policy back to you under Code Section 2042 and not 2035. So the big question is, could you avoid this with a sale? of the policy instead of gifting it? Yes, maybe, but there are some caveats. So for one, there's no bona fide sale exception under Code Section 2035 or 2042. So with other retained interest provisions we've looked at, I cite 2036, 2037, and 2038 as specific episode topics I've covered. And then 2041, general powers of appointment. All of those allow you to reduce the value of what's included in your gross estate if you can prove in full or in part that there was a bona fide sale for full and adequate consideration. And if you don't really meet the full fair market value, it can at least reduce potentially the value that's included in your gross estate by the portion that you sold. But in this bona fide sale exception, there's no reference to Code Sections 2042 or 2035. So what that means, it doesn't mean that you can't avoid the application of Code Section 2035 by sale. You can still take away that 3-year look back with a sale of the policy, but what it means is there's no room for error here. So if the sale price of the existing policy ends up being less than the policy value is determined for gift tax purposes, then you blow the transaction. That means the entire death benefit still gets included in your gross estate. So there's no room for error when it comes to pricing. So it's better to overpay, or it might be better or easier if underwriting permits it to have a different owner purchase a new policy instead of trying to gift or sell the existing policy in question. And from an income tax perspective, I mentioned the transfer for value rule earlier, how that can blow up the income tax exclusion on the death benefit. So there are exceptions to that, such as a sale to the insured, a sale to a partnership or another partner in which the insured is a partner of the partnership itself, or a sale to a corporation in which the insured is a shareholder or officer. Now, we're not going to get into those exceptions, and I've covered them in a previous episode, but importantly, what this does is it takes away your ability to sell to another family member to avoid the gift and income tax issues. You could generate additional income tax problems as a trade-off for avoiding the gift and estate tax problems. I've also talked about, in a previous episode, Goodwins situations. And those arise in a situation where you have 3 parties involved, the insured, the owner, and a beneficiary, and they're 3 different people. So if after the sale or the gift, the new owner is not also the beneficiary, this can cause those policy proceeds to become subject to gift tax and or income tax when they're paid out. So that's why it's not a good idea all the time to transfer the policy to a family member in lieu of transferring it to a trust. So how do we get around some of these issues? Well, for an existing policy, most of these issues can be avoided if you make a transfer by gift or sale to an irrevocable life insurance trust, an ILIT. So for one, as long as the ILIT's the owner and beneficiary, that eliminates the application of Code Section 2042 and of a Goodwins situation, as long as the insured is not also a trustee or beneficiary of that trust. 2, as long as the policy is gifted to the ILIT more than 3 years prior to death, or purchased by the ILIT at any time for at least the gift tax value, then we avoid Code Section 2035. Then finally, as long as the ILIT is a grantor trust, we avoid the transfer for value rule because technically the insured is the owner of the trust for income tax purposes only, but not for purposes of Sections 2042 or 2035. So technically, that would be a sale to the insured, which avoids that income tax issue. And ultimately, with all of these, if underwriting based on age and health status makes it economic, you may want to explore having an ILIT purchase a new policy so that we avoid all of these issues and don't really get into that gift tax or sale valuation and whether it's valid. In other words, if a new policy is purchased, the insured is never the owner, and we never have to worry about any of these issues. So, in an upcoming episode, there's more to come on this. We're going to dive into this a little bit more because life insurance is going to become more popular, especially with the liquidity crisis looming for a number of estates if the applicable exclusion amount is reduced from $11.7 million to a much lower amount. I'll have a guest speaker on in the future who I'll introduce at a later date, who's going to talk about some of the product options, some of the underwriting options, and some of the premium payment options that might apply in ways that you're not anticipating. This isn't the usual presentation that we have coming up. It's going to be a little bit more outside of the box. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. And as an aside, I'm testing out, if I sound muffled, it's because I'm experimenting with our mask mandate to see if the wearing of a mask muffles out some of the pops and S's in my voice. So just kind of a cheap audio editor type of technician tool that I'm using without having a filter for my actual mic. But that aside, thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.